Ladies and gentlemen, just before we recommence the cross-examination, let me once again urge both parties, please, to provide to the interpreters as early as possible all the bundles, all the slides. It makes it extremely difficult for the interpreters if they do not have this information beforehand. It's causing real problems. The information is available, so please make sure that you provide it to the interpreters beforehand. They will not distribute it to anyone else. They will observe the confidentiality, but it's absolutely essential that these folders are provided in advance. And I'm making the point now because this is going to be absolutely essential as well for any slides or other documents that you're going to use in response to your questions to the tribunal and for your presentations tomorrow. I really do not want to be in a position where we're going to have to raise this question again. The interpreters really need to be on notice, please. So without more ado, Mr. Hayden, you're still in the witness seat. Ms. Hayworth-McCandless, over to you.
Thank you, Mr. President. So, Mr. Hayden, we're going to talk about severance damages. And if you look at your first report on page 21, which is under tab 1 of, well, you can look at it wherever you wish. But if you're looking at the black binder, it's under tab 1. And page 21. And the second full paragraph, in the middle of that paragraph, you're describing severance damages. And according to your description, severance damages occur when a parcel is only partially expropriated, correct?
That's when it may occur.
Okay, fair enough. And severance damages are the damages that result from a decrease in value to the unexpropriated part of the land due to the expropriation of part of the land. Is that correct?
Yes.
And to calculate severance damages, you analyze the parcel before the taking and then after the taking. Then you subtract the expropriated portion and compare the value of the remaining parcel before the taking with the value of the remaining parcel after the taking, and the difference is the severance damage. Is that correct?
I believe what you said, if you value the property before and you value the property after, and you take a subtraction, if you will, between those two positions, the resultant number is the value of the part taken, which may include severance damages.
Right. For the purpose of calculating the severance damages, then you subtract out the expropriated portion and you compare the value of the remaining parcel before the taking with the value of the remaining parcel after the taking, and once you've already taken out the expropriated portion, then that difference is the severance damage. Is that correct?
Yes, and you take the expropriated portion of that out at the before value, and then the remainder then becomes the allocation to severance damage. That's correct.
Okay, thank you. To calculate the before taking value of the lots that are allegedly partially expropriated, you used comparable transactions of other beachfront properties. Is that correct?
Yes.
And let's look at an example. If you could please turn to pages 62 and 63 of your first report. And this is with respect to lot SPG 1, correct?
Yes.
And looking at the table on page 63, on the top square is the before taking value, correct?
Yes.
And the bottom square is the after taking value, correct?
Yes.
And in the before taking value, we're kind of in the middle of the box, it says physical, and you have beachfront, 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 beachfront. So there you're assuming you used comparable beachfront properties to value the entire lot before taking. Is that correct?
Yes.
Thus, the before taking value of properties reflects their location on the beach. Is that right?
Yes.
And a beachfront location is generally more valuable than a location that is not beachfront, correct?
Yes.
And that is because the beachfront location assumes a beach view or beach access, is that right?
Generally speaking, that is correct. However, it really goes to the proximity of the amenity that is part of the valuation theory.
And if you subtract the beachfront portion of the parcels because of the expropriation, you are left with a remainder parcel, correct?
Excuse me just a second.
Oh,
Thank you. Can you please repeat the question?
yes, I will. If you subtract the beachfront portion of the parcels because of the expropriation, you are left with the remainder parcel, correct?
As was expropriated in this case, we have expropriated in the partial takings the most proximate land to the beachfront, and then the remainder is not as proximate. That's correct.
And to determine the value of that remainder parcel after the taking, you used interior properties as comparable transactions, correct?
Yes.
And the second table on page 63 reflects that and says physical, and the line there has interior lot, interior lot, interior lot, interior lot, correct?
Yes.
And to be clear, interior lots have less value than beachfront lots, correct?
Yes.
So we have the complete lot before the taking valued as beachfront property. A portion of that beachfront property is expropriated, which leaves a portion of property that is still valued as beachfront property. Is that correct?
Could you repeat that question?
Sure. So we have a complete lot before taking valued at beachfront property, as beachfront property, and a portion of that beachfront property is expropriated, which leaves a portion of property that is still valued as beachfront property. Is that correct?
I believe it's not correct because the remainder land is valued as interior lots.
Well, in your
And interior land in the second section here. I think
right,
that's right.
I'm sorry. To be clear, I'm talking about the first part, in the before taking part. So and I'm talking about the portion that's not been expropriated, and I'm talking about how you're applying your severance calculations. So you have a complete lot before the taking, valued as beachfront property, and a portion of that is beachfront property is expropriated, which leaves the remaining portion of the property. And for your calculation of severance damages, you are assuming for that the before taking value of the non-expropriated portion is beachfront property. The value you give to that is beachfront property, right?
No. The value in the after take is valued as interior lots, as shown in the lower portion of this page 63.
Well, yes, after the taking, when you're subtracting the value one from another, the second amount is the amount calculated as an interior lot. But you're subtracting that from a value of the lot that I believe you're giving is the beachfront value. The difference is the severance. Isn't that correct?
Again, we've gone around this a couple times, but it's shown clearly in my presentation earlier on one of the slides. So it's the before value at the larger lot theory and the before value at the 207, and then in this case with this parcel, there were 3,000 square feet expropriated, so that was ascribed at the $207 per square meter. And then after that has been subtracted, then the remaining lands is then ascribed as interior. And then when you do that arithmetic, then the resulting value is then considered the severance. Then when you add them back together, you get the total compensation for the part taken as well as the remaining land, which now has to absorb the lost value from the front portion.
Okay, then it might be a little bit easier to take a look at a visual for this. And if you look at Navigant's report and the second report behind tab 7 at page 30. And this is based on a development plan for SPG lots, is that correct?
Yes, it is.
And it's in the record as Exhibit C40. The 75-meter strip is valued as beachfront, and the interior, this part behind that, is considered interior lots. And for your initial, before taking, the entire portion, 75-meter and the interior lots, are all valued as beachfront lots. Is that correct?
Not beachfront lots, but it's valued under the larger parcel theory as one unified parcel at one unit rate.
Correct.
That's correct.
And the unit rate is the beachfront.
We used beachfront comps, but they were significantly adjusted downward to the $207 per meter value that was ascribed to the entire parcel. Even though we used beachfront comps, you'll notice that there's a significant price reduction in our adjustment downwards to the $207 per square meter, reflective of the entire lot, using beachfront comparables adjusted.
Okay. And if you look at figure 10, which is on the next page, on page 39, assuming a partial expropriation of the 75-meter strip of land that is located within the national park, the remaining parcel begins with a section marked new beachfront. So the parcel now would be new beachfront plus interior lots, correct?
I would not characterize the green area as new beachfront, but it is then the green plus the remaining yellow that are considered interior lots in my analysis.
Okay.
Interior land, I shouldn't say lots, interior land.
And for the purpose of that valuation for the post-taking, then the green plus yellow is valued in your severance damages calculations as being interior lots. Is that correct? The comparables you used were for interior lots.
Yes. We valued that as interior land using interior lot values.
Yes. But as a practical matter, the space that constitutes the green and yellow in figure 10 and the space that constitutes the yellow in figure 9, they haven't moved, have they?
No, it's stationary.
So they are as close in figure 10, that land is as close to the beach before the taking as they were after the taking, correct?
And what land are you alluding to?
In figure 10, the green plus yellow.
Is the same distance physically
Yes.
as what you have in figure 9. That's correct. They haven't moved. Only the lot, only the buffer has, that the pink area has moved.
Well,
encroached on the remaining land.
It hasn't physically moved, though, has it?
No.
And the government, so you're as close, you're as close to the beach before the taking as they were after the taking, correct?
They're physically as close, but it's been detrimentally impacted by the insertion of that pink space.
And that pink space is the 75-meter strip that the government expropriated because it's a park, which means that there is not going to be any development there, no buildings, no houses. Isn't that correct?
That is correct. There will be no buildings. There will not be any access, and there will just be continued growth of vegetation.
So the new beachfront lots, the ones that are in the green strip on figure 10, have all the same qualities as the old beachfront lots. Isn't that correct?
No, it is not.
They're physically in the same location. They're not any further away from the water, are they?
They're not physically further from the water, but they're clearly further away from the amenity that one would think. Again, in valuation, it's clear from an economic perspective, if you're closer to the amenity, you have a higher value. Like any sporting arena, if you're sitting close to courtside, you pay higher for the seat close to the court than you do to the back. And if you think about it here, if my land was only at 50 meters away, If you're a golfer, that's an easy lob shot. And if you're, now 125 meters away, that's a 9-iron. And if you're a soccer player, I'm at midfield or I'm behind the net now, watching behind the goalie. So, or a football player, I should say. So the end of the story is physically they haven't moved, but from an economic perspective, dynamically, the land clearly in the green now is not as valuable as the area in the pink. Even though they physically haven't moved and there's this buffer now in front of them where I can't access and I have vegetation growth that I can't control, yes, there's a diminution to the area in green and yellow.
And so the interior lots are less valuable than beachfront lots, is what you're saying, correct?
The land further removed from the amenity is less valuable, and that's a standard valuation premise and depth table that's been going on since the 40s in terms of land valuation. And economically, I think it's a pretty well-proven principle that anything further from an amenity is less valuable.
And so the resulting difference between beachfront and interior, that calculation is higher than it would have been if you had compared beachfront before expropriation to beachfront after expropriation. Isn't that correct?
The values were adjusted accordingly so that the spread between the values before and after made sense relative to the adjusted comparables. And then when one steps away and looks at the total value of being paid for the part acquired, as consistent with my theory, it makes sense that that is the difference in value between the before and after. And it's in valuing the total part taken that one is looking at in the overall analysis here.
And in your direct examination, you discussed properties and you made a distinction between the SPG lots and the B lots. And the SPG lots, you said they were, notwithstanding the fact that a portion of the lot was taken because of the size of the lot, you said that, and the ownership there, you say, and this is on page 733 of the transcript, beginning with line 7, we see that the before value has been enhanced by the unified ownership of the larger parcel. So here we go on then to a larger parcel because SPG 1, 2, and 3 are all owned by one individual, and they can all be unity of use, unity of title, and then physical, so unity of use and unity of title, correct?
And physical contiguity, correct? The physical collect, yes. So yes, that is correct. Those are the three economic principles relative to an after parcel assemblage in highest and best use.
And then you indicated that it was different for the B lots because when you take away a portion of the B lots, that it left a portion that couldn't be developed, and therefore that had a larger severance damage calculation that you made. Is that correct?
Correct.
Are you aware, let's see here, if you turn to page 26 of your first report, which is behind tab 1. And the B lots are there in the lower portion of the map. And it's actually kind of hard to see on this map, but behind the B lots are properties. Are you aware that those lots behind the B lots are also owned by Mr. Berkowitz?
No, I have no information that led me to understand that they were owned by it. There was a conversation that he owned other land in the area, but I did not know exactly where they rested.
And if you had that knowledge, would you make an adjustment to your damages calculation such that you would not give the greater value for severance that you did to the B lots with the understanding that there was no unity of owner and no unity of title?
Can you repeat that question, please?
Sure. If you had the understanding that, if you knew that those lots behind the B lots that are shown in this picture here belonged to Mr. Berkowitz, would you feel the need to adjust your severance value to reflect it more along the lines of what you did with the SPG lots? Because in that instance, there would be unity of title and unity of ownership.
I would have to take that under advisement, but if it met the test of unity of use, unity of title, and physical contiguity, and they weren't separated and could in fact be joined, they would get similar treatment then to then the SPG lots, and/or how I ascribed a value to B lots 5 and 6, where they were adjoining and could be assembled to create one plus minus 8,000 square foot lot.
Okay, thank you. Let's go back to the issue of beachfront view. And as we had discussed earlier, you valued some of these properties as beachfront properties. And you provided photos in your first reports of views of the beach. Let's turn to those photos on page 88 of your first report. And at the first photo, which is the entitled North View of the Beach from Lot V32, in these photos, you see the dark vegetation that follows that line on the beach?
In the bottom south view or in the top north view?
Actually in both, but in the top north view as well as the bottom south view.
Yes, I see vegetation in the distance.
Right. That is the berm or tree line, or the beginning of the vegetation, is that correct?
In the northerly view, in the top of page 88, that rise or elevation is significantly off the property line. That is a beach view, so that is not of question. But I think that what you might be alluding to is in the south view, where you see the vegetation to the left of the photo or to the rear of the photograph. Yes, that is the rear. That is the line where vegetation begins to commence.
And a large hedge-like mass of vegetation at the edge of the beach. The same berm that claimants claim keeps the turtles from being disturbed by the lights and noise of the urban development. Isn't that correct?
Could you repeat that question, please?
Actually, I will withdraw that question. Claimants' properties are located on the land side of the berm. Is that correct? On the other side of the berm?
You allude to a berm. I would call it the 50-meter inalienable zone.
Well, I guess I'm trying to call it the tree line. It's the vegetation line.
Yes, looking south on page 88 in the southerly picture, you'll see a row of vegetation in the distance. And yes, the claimant's property lies to the other side of what you can see in that photograph.
Would it surprise you to learn that Mr. Berkowitz, during his cross-examen, described that vegetation as a, quote, green curtain, close quote?
I object to the question.
It's just a question as to whether or not he would be surprised if he learned that information.
I think you can put it in terms that don't go to Mr. Berkowitz's testimony.
Okay. So there is a large amount of vegetation that is there behind which the property exists. Is that correct?
There is vegetation behind which the properties exist.
And from claimant's properties, well, let's take a look at a picture. If you go to page 62 of your first report.
Yes.
And that is lot SPG1, correct?
That is correct.
And is that a picture looking towards the Pacific Ocean, or is it looking from the Pacific Ocean? It doesn't say.
It is a picture looking westerly from the road on the back of lot SPG1 towards the west and towards the ocean.
So you would agree, would you not, that from that perspective there isn't much of a beach view there, is there?
Standing on the ground at the rear of the lot, there is not much beach view, correct.
The total amount of severance damages that you have valued is $13,045,005. Is that correct?
Can you be more specific?
The total amount of severance damages that you have valued is $13,045,000. $13,045,005. Perhaps, well, let me take you to that amount, and then you can tell me if you disagree with that. And Navigant's first report, which is behind tab 6 of the binder in front of you, at page 20. And there's a table, table 4. Do you see that?
Yes, I do.
And if you follow the column, the second to the right, it's entitled Severance Damages. And you go down to the bottom, and Navigant has identified the values of severance damages based on your report, and they come up with the total value at the bottom of $13,045,005, correct?
That's what the number shows, and if that's an accurate reflection of what my report shows, then I will agree that that's what that says.
Okay. And the total amount that you have valued for damages in U.S. dollars is $36,203,000, correct?
Based on my earlier testimony, I think we amended that given the recalculation of Lot A39 and A40, and I believe that on slide 24, we now show a total compensation or just a value of the parts taken at 36 million. Sorry, this is value of the land taken with severance damages of $36,608,000 U.S. dollars.
Okay. So even with that revised calculation, your severance damages constitute about 1/3 of your total damages calculation. Isn't that correct?
If you were to do the math, yes, it's probably about 1/3 of the value that is then ascribed to the lost value of the front portion that is now allocated over the rear portions of those lands.
Thank you. I have no further questions.
Thank you very much, Ms. Cohen.
I do have just a couple of questions arising. If I may just have a moment. Mr. Hedden, if I could ask you just to look at page 62 of your report. You were asked a moment ago about the photograph on page 62 of the report, and you said standing from the rear, I think you said standing from the back of on the ground from the rear of the lot. I can't remember your exact language, but I think you said there wasn't much of a beach view. Can you tell me from your observation, if you were standing elsewhere on the lot, what the view from that lot was?
Standing at a different portion of the lot where you might have a building envelope and the property would be constructed, you can see this is a winter shot, and there is the Minera Negro of probably, let's just say, 15, 20 feet, with a building could be built up to 9 meters and 36 feet. So with a height, and so if you looked at Mr. Gramillion's plans of a second story and an appropriate building envelope with a reasonable setback from the 50-meter inalienable space zone, one would be able to see over the Minera Negro of sunsets and hear the lapping of the water and possibly see beach views and the beach itself and the ocean.
Mr. Hedden, just one other question, and conveniently it's on page 63 of your report. You were asked about the second portion of the analysis on page 63, and you were referred to the fact that you have used interior lots as comparables with respect to the after taking.
Yes.
And with respect to those interior lots, can you tell me from your observation and from your analysis at the time, what is currently in front of those comparable lots that you've used?
They are on the other side of the road. So across the road from them would then be this new 75-meter setback, and in front of them now are other properties that are now currently beachfront, and so it's on it's behind the road, and there is some other vegetation and development in front of them.
And when you say that there's other vegetation in front of them, did you, in your knowledge, was there any, you've also indicated that that's now part of the 75 meters beyond the 50-meter inalienable zone. Do you know whether the lots in front of these lots that you've used here have also been expropriated?
Yes, they have, or intended to be.
Thank you. Those are my questions.
Thank you. We have a number of questions from the tribunal. Mr. Cantor.
Mr. Hedden, thank you for attending. My name is Mark Cantor, and I'm one of the arbitrators. First, I understand from your reports that you prepared them in conformity with the Code of Professional Ethics and the Standards of Professional Practice of the Appraisal Institute. What is your understanding of the responsibilities that you owe to this tribunal in light of that code and those standards?
To be ethical, to have no bias, to represent in my best professional judgment a credible opinion of value.
Does it include a responsibility to provide this tribunal, to owe a primary duty to this tribunal rather than to the party who instructed you?
The only instruction that I may have received was the date of value, and to the extent that I agree with that date of value, that is the only instruction that I may have received. The rest of the conclusions, opinions set forth in my report are my own.
Thank you. Does the code and the standards, do they include a responsibility on your part to owe a primary duty to this tribunal rather than to the party who instructed you?
Yes. Part of the code of ethics that we ascribe to is for public trust and to be as impartial as possible. And therefore, in that sense, I have presented what I believe to be a fair opinion of value to this tribunal today.
Thank you. You have used the phrase the scheme to describe that conduct of the state that you did not take account of in determining any reduction in value because it's attributable to the scheme. Do I correctly understand that?
Yes.
Could you describe for me your understanding of what that scheme is?
The scheme in the context and my understanding as it relates to this matter would be then the expropriation of the property that is part of the 75-meter request of expropriation. And to that scheme, it was for a period of time. And so that when, starting back even as early as 2003, through our data value through 2008, there was this involvement, if you will, in the marketplace that has been evidenced by broker behavior, as we discussed before with Penelope Lent, that would insert some market resistance to the transactions. And so It was as a result of this involvement, if you will, of the plan, of the scheme, then to interfere with the actions of buyers and sellers and allow certain discrimination to occur, is what I allude to as trying to ignore, if you will, the scheme and the influence of the scheme in the marketplace.
In any marketplace, there is a certain level of government involvement, regulatory measures, that is lawful. And there is a certain level of government regulatory measures that is not attributable to expropriatory conduct. You would agree with that?
Yes.
Did you make an effort in analyzing what you describe as the scheme to distinguish between government conduct here that would be lawful and would not be part of expropriatory conduct, and government conduct that you could identify or was identified to you as unlawful or part of a scheme of expropriation?
Not being a expert in law and do not practice law, the lawful or unlawful is something that I cannot comment on. What I can comment on is my expert valuation and the denial of building permits and the experiences that the property owners had gone through with submission of plans or submission and requests for permits that were not issued, the behavior of some of the brokers to not show or sell properties. That type of market interference affected the value, and that's what I can talk about. The lawlessness or the, excuse me, I said lawless, the unlawful nature of what was done. I am familiar with police power and government's ability to expropriate, and so those issues I am aware of. However, my only concern and expert opinion here goes to its effect on value.
Appreciate that. What I'm trying to understand is, in determining that effect on value, did you seek to distinguish between any category of regulatory conduct that was, if you will, permissible, and a category of regulatory conduct that should be excluded from your analysis of the amount of compensation?
No, I made no distinction.
What methodology would you use for the purpose of trying to draw such a distinction?
What I can what I will testify to today, and what I have viewed in the market, and it would be then the fact that in other markets, in Hacienda Pinilla or further up in Las Carolinas or some of the other markets where you had value growth in La Costa, where there was in my exhibits here, you'll see that, and even from the evidence from the other brokers, what they believed then the values of these oceanfront lots were to be as compared to what was actually occurring in terms of Playa Grande and Ventanas. So trying to make the distinction, we can only see that there was market resistance because of the problems that came from the clarity or lack of clarity, I guess, from the government authorities, so that the expropriation didn't move forward, and because of various rulings, and therefore the uncertainty and the cloud that existed, again, caused this loss in value. So the only way I would think of being able to allocate, differentiate, or try to measure that would just be to look at certain control neighborhoods and the subject property area and try to distinguish the loss in value that's attributable to that behavior. It's the only thing I can think of.
Would that methodology treat all government measures directed to the relationship between the park and the surrounding private lands as part of the scheme?
I'm not sure about your question. Could you repeat it, Mark, please? Excuse me, Mr. Cantor. Or, give me some clarity on that.
Let me back up then. you've used a couple of phrases to describe the scheme. One is involvement, and the other is a cloud. I'm trying to see if there is a distinction between involvement of the government that lies short of either unlawful conduct or expropriation, an involvement of the government that is unlawful or expropriatory. And I appreciate that it is not your task to draw that line for me. But I am trying to understand how one would go about trying to identify a diminution in value attributable to conduct that was unlawful or conduct that was expropriatory, as opposed to regulatory conduct that may have been interference with value, but nevertheless was lawful or not expropriatory. Your answer, and I'm finally getting around to trying to clarify the question I asked, your answer to me appeared to say, I would look at conduct in other areas, and I would compare it with conduct here. Those other areas, however, do not border the park. The conduct at issue here relates to the park. And I'm trying to understand lawful government conduct related to the park, government conduct related to the park that is not expropriatory on one side, and government conduct related to the park on the other side that is unlawful or is expropriatory. What methodology you would use to distinguish between those two categories for purposes of evaluation.
In listening to your retort then, I now have gotten some clarity relative to an appropriate response in my experience. And that would be the immediacy of the government action to execute the plan. And in saying that, it's been my experience in many other expropriatory or eminent domain issues, and it would be that the government comes up with a plan, they move forward, they expropriate, they compensate, and the plan moves forward in redevelopment or whatever the plan is. In his case, it's his park. When it's drawn out over a period of time and the market is allowed to then languish with uncertainty, it's then, so getting back to that, it's the immediacy of coming up with a plan and moving forward so that the market is now, and the property owners are compensated in that point in time. But when it's drawn out is where the damages or the unlawfulness, if you will, and again, I don't want to use the word lawfulness, but where the complications occur because it's now caused a delay in the highest and best use, the ability for the property owners to enjoy all the fruitful benefits of that property because of a protracted period. So how would you measure that? So the measurement would then be some time value of money that's what I'm thinking off the top of my head from a methodology perspective, because it really goes to the risk and the delay that has been caused as a result of the uncertainty of the government to move forward and execute the plan consistent with the law. So whether it's, again, issuing the certificates of interest, of then moving on the eminent domain, the expropriation, compensating the owners and taking title and fee, because that way then the property owners in fact have their compensation and they can use those dollars and that compensated dollars, colones, to do whatever they want, or they move on. But the fact that there's been this no-man period of time has really been the more damaging issue, I think. I wish I could be more clear.
Thank you. In thinking about a, quote, scheme, unquote, here, I want to read you some words, and I want you to see if it in any way affects your thinking about what conduct does or does not get taken into account in valuing property for expropriation purposes. Compensation shall not reflect any change in value occurring because the intended expropriation had become known earlier. If you like, I can repeat that language to you again.
Yes, one more time, sir. Thank you.
Compensation shall not reflect any change in value because the intended expropriation had become known earlier.
Okay.
You'll appreciate that language, the word intended expropriation, and the phrase had become known, a knowledge test, or operative provisions of that language. Does that alter in any way the way you would think about the impact on value here?
No.
Why not?
Under my definition of market value, and to the extent that we have then selected comparables that were reflective of users of the property who were going and intending to acquire the property for their use, and ignoring then the possibility, if you will, or that the property would be expropriated in terms of the value that was indicated. And then, in fact, then notwithstanding the intention having been for a protracted period of time, that influence was ignored in my market value conclusion, and therefore what you have read, I believe, is consistent with the value set forth in my report.
My next question, I'm not asking for a legal answer, I'm going to ask for a valuation answer. If immediately before the acquisition of an individual item of property, the prospective acquirer had known of the intended expropriation, would that affect your thinking about value for purposes of the expropriation, the later expropriation?
Can you just repeat it again, Mr. Kinter? Only because you said the acquirer. Would it be the condemnor, the acquiring government agency, or are you saying in the arm's length transaction between a willing buyer, willing seller? I'm confused.
I'm referring to the arm's length transaction.
Okay.
I'm sorry. No, let me back up. Neither. I'm referring to the landowner, the prospective landowner, immediately before acquiring the land that later became the subject of an expropriation. So I'm looking at the date of the purchase, if you will, the initial purchase. And what I was asking, if immediately before the acquisition by that prospective private sector landowner of an individual item of property, for example, a lot in this proceeding, that prospective private sector acquirer had known of the scheme, as you put it, the intended expropriation, and then consummated the acquisition of that lot, would that affect your thinking about value for purposes of the later expropriation by the government body?
Not when it can be shown, like in the acquisition of Ventanas Lot 61, where there was a willing buyer willing to pay what I consider to be a market value for that lot, with the understanding that if they didn't get a building permit, it would be rescinded. So there was knowledge of the acquirer prior that there was a risk of expropriation, but was willing to go forward and apply for a building permit. And to the extent that the permits were not approved, then there was a reversionary provision, so that there was full disclosure, full knowledge, but the price paid was reflective of what I felt to be market value for that property at that time. So that it would not have, in fact, then therefore it did not affect my value conclusion because of that market-based transaction.
A couple of questions based on that. First, there could of course be another category of property where the acquirer did not include in the purchase contract any right to put the property back to that seller. Therefore, the acquirer was, in commercial terms, taking the risk that there would be a later expropriation. Does that alter your thinking for that type of property?
Yes, it would.
How?
Because if without the put, if you will, without the ability to revert, I would be speculating that I would be awarded a fair market value for my property if, in fact, the expropriation went forward, and whether or not I would, in fact, receive the amount of money that I spent to acquire that asset.
Thank you. You testified that the marketplace for these properties in this particular area over the relevant period, there was a lack of an efficient marketplace, a lack of a transparent marketplace. And later you used the phrase lack of active, efficient, transparent market. I understand your methodology here to have largely been to try to overcome those weaknesses in the marketplace by identifying properties that were as close to comparable as you could find, and then to make adjustments to try to establish comparability. Is that a correct understanding of what you sought to do?
Yes, and at the same time, just to elaborate briefly, and to compensate for the part that was taken, to arrive at an appropriate value for the part that was taken.
In light of the weaknesses in the market that you identified for trying to find comparables, what methodologies other than the approach you took would be available for the purpose of trying to identify a fair market value of that property at the time of the alleged expropriation, taking into account the language that I read you about an exclusion not reflecting any change in value because the intended expropriation had become known earlier, but otherwise a fair market value measure?
The information that I received during my interview process, so to complement the data that we have described here, the comparables, there was significant time spent interviewing market participants, and when it's as an appraiser who reports the market, appraisers don't make a market report. We report the actions of the buyers and the sellers, and specifically the brokers that are involved with trading those properties. And through the, say, 5 interviews that I conducted with the market makers, if you will, the brokers that are most active in that market, all of them came back to me with, again, the letters that we shown in the exhibits, confirming those numbers and telling me, and I truthfully believe them, that they were, in fact, truthful, that those were reflective of the values, and that there was this cloud in the market that precluded an active market and somewhat of a stigma. And therefore, I took that information, coupled with the news reports, coupled with the all the other publicity about the excitement in the Costa area, as part of my methodology, if you will, to survey and to then use that anecdotal information combined with the hard evidence that we've shown in the report to ultimately conclude to my value. And that's an appropriate methodology in my expertise.
I follow that testimony. I was asking, is there an alternate methodology?
Than the one I have just described?
Correct.
Not that I believe is in any of the treatises or any of the training that I've ever had in terms of real estate valuation.
I've seen proposed in connection with valuations in circumstances where comparables are not available and the property does not lend itself to an income method such as a discounted cash flow. The one means of estimating fair market value in those circumstances would be to identify the original purchase price and then seek to calculate over the duration of the entire period from the original purchase until the valuation date, an average rate of return on that profit. That is obviously not property-specific methodology because it's an average rate of return for the relevant market. Is that an approach for which data is or could be obtained for these properties, in your professional view?
Yes, I believe that, again, relative to these specific properties, I believe it would be very difficult. In listening to your description of an alternate valuation methodology, which I will then characterize as what we call trend and bend, the using of a prior asset price and then trending and then seeing if that is reflective of a current market value is a methodology that I wasn't thinking of before. But yes, is done. It's done with fixed assets. It's done in other types of asset classes. In the specific case, as I've talked about in my reports, trying to do that from prices that are not necessarily reflective of a market value at that time, you could try to calculate return on investment and to determine whether or not that's an appropriate return or not. But I'm not sure that that would really work in the case because of trying to trend and bend value prices that were paid. Unless you're able to establish that they were market values at the time, don't necessarily get you to the right point in the conclusion, because then they're not supported by the market value. And I'll say this about the market being in Costa, and what I've learned about Playa Grande and Ventanas was that the market was appreciating so differently and drastically, and not there was no, again, the transparency, the homogeneity, all that. I'm not sure that that would be a valid methodology in the subject case. It's a valid methodology in other cases, in other locations maybe, but I don't think that in this case it would be probative.
Leaving to one side your bottom line conclusion that you're troubled as to whether it would be probative, the starting place for that kind of an approach, that kind of a method, excuse me, would be the purchase price of the properties. Would that need to take account of any unusual provisions in the purchase contracts, for example, the existence of a put or the non-existence of a put?
Yes, I think that that would be part of the consideration. And along the same lines of your questioning here, when you look at the price that was paid for lot C71 in terms of the transaction price and then my ultimate value conclusion, you can see that there is a slight increase consistent with my value trend. If you look at lot V61, which was acquired at $3.1 million and now appraised at $3.8 million, I'm using round numbers, 3.8 when you add V1, V61A, B, and C together, from 3.1 to 3.8, and then you look at the time variation between those to what I valued it today and what it was acquired for, you'll see that's consistent with the value trends that we've applied. So in those two situations, that trend and bend, if you will, holds up under your theory. However, in the earlier cases, and again, that in V61, we've talked about that there was a put, but that didn't seem to reflect the value that it was paid at $3.1 million. Other than the fact that there was the assumption that there would be a building put on it and that there was the ability to escape in the event that the permit wasn't issued. In the subject cases, because of the variation in prices, I'm not sure that trend and bend universally applies to the subject market.
I realize I should have said something at the very beginning for the benefit of everybody who's listening, which is that we all appreciate that no one on the tribunal has made any decisions about jurisdiction or merits. And the reason why I'm asking questions about damages is not because I have a view whether damages are or are not appropriate, but it is important at this stage to clarify the damages evidence if it ever became relevant to the decisions of the tribunal. I just want everybody to appreciate that point. Two other very quick points. First, you calculated value here as of the date in 2008, based on an expropriation theory. As you will appreciate, there are also claims here that are not based on expropriation theory. And whether expropriation is the proper theory or those other claims are the proper theory, there may or may not, under applicable law, be different valuation dates. Did you calculate values for any date other than the date you were instructed to use in 2008?
No.
Did you obtain information that would enable you to calculate values for, by way of example, either the end of 2010 or a date roughly contemporaneous with the arbitration award?
No, unless I were to go back and redo all of my work again, I'm not at this time.
And on the last topic, the severance topic that you were discussing with Ms. Howarth McCandless, I wonder if you could just turn to that map that we were looking at, which is on page 18 of your slides, and also on page 30 and then 31 of Mr. Kaczmarek's second report. It doesn't matter for my purposes which of them you're looking at.
I'm looking at the slide, my presentation this morning, page 18.
Very good. And that's the equivalent of the map that's found on page 31. No, excuse me, on page 30 of Mr. Kaczmarek's second report.
That's
figure
correct.
9. The first set of lots in the yellow, after giving effect to the asserted expropriation, those would then become the lots closest to the beach, the ocean, and the turtles, correct?
Yes.
Do you know what that plan contemplated by way of height for buildings built on that line of lots?
No, I do not.
Do you know whether that line of lots, even if there was no purported expropriation and the 75-meter strip remained in the property, would have views of the beach, the ocean, and the sunset?
It's my understanding from looking at other two-story dwellings in that location and that proximity to the water that you could in fact have those views. The code that I was referring to earlier allows for 9 meters of height. Looking at Mr. Cremillion's plans, the second story would go to about 22 or 23 meters. So I believe then that there was 12, I think it was a 12 meter and then 12 meter height. Again, my best recollection would have to look at the plan, but the point is that I believe that a view would be possible.
Do you know whether there would have been a difference in view if the 75-meter strip, the 8 lots that were contemplated for there, had been built up to a size permitted by the applicable codes, in comparison with a situation where those houses are not built, but rather you have forest of the nature of the scrub trees we've seen in the photographs?
I believe that it would be not as favorable. Again, the fact that the vegetation would grow unabated as compared to now where you can clear some of the Madera Negra with permitting and to keep that vegetation down. So I would believe that it's not only that, it's the denial of the access, where I was able to walk to the beach from the B lots without just cutting through the inalienable zone. Again, and now walking for another 75 meters in addition to the 50 is clearly not as desirable. So it's a couple of things.
Looking at that map, unless I'm mistaken, there was only one contemplated unblocked access for the second, third, and etc. rows of lots, and that was an access road cut through the middle of the green area, marked by 2 lines right in the middle. Do you see that?
Yes, so if you're looking at page 31 of...
Correct.
Yes, I see how there's a bump out in the middle of the green area that kind of cuts across some lots there. And the question would be, how would you access those interior lots based on this plan? Because you can see then that there's, for those lots, the line just kind of cuts right across. And so,
So is the difference in access, rather than the difference in view, for the lots in the yellow, only the question of whether one could build a private access between two private lots, as is drawn in the green on that page, versus walking through parkland to get to the beach? Is that the difference in access?
it's the walk, but then there's also the fact that, crossing it, my understanding was that now the access for the beach for those remaining parcels would be then further down into Costa, further down into Playa Grande at a public access point.
Is it your understanding that one could not walk through parkland from this development to the beach directly?
Yes, I believe it was my understanding that the 75-meter strip would not permit direct access.
I'm asking about walking access, of course, not asking about automobile access.
I'm unclear on that, sir. I don't know.
Okay. Other than ocean views, sunset views, sight of the beach, the white sand, and access to the beach, as we've just discussed, are there any other attributes of beachfront property, in your view, for purposes of this land?
I think that sums it up, sir.
For the first row in the yellow, if there are not 8 lots in front of that first row, privately owned, but rather parkland after giving effect to expropriation, would that have any positive impact on the value of the first row of 8 lots, putting them next to parkland?
Yes, I believe access to does have some benefit, but there's also the detriment to the extent that it's not going to, who would maintain it, all right? So it's parkland, but it's left to grow, again, with the Madero Negro and the underbrush, just to grow unabated, and therefore just becomes additional separation, if you will, from the amenity being the beach. But so that there'd be offsetting considerations for sure.
Would I be correct to assume that for some purchasers, having land abutting a park is an attractive feature rather than a negative?
Oh, yes, you would, sir, yes.
Mr. Hedman, thank you for your patience. Mr. Chairman, no additional questions.
Thank you. No questions for you? No. Mr. Hedden, just 3 very brief questions from me to clarify 1 or 2 issues, 2 of which go to points that Mr. Cantor has already put to you, but I'd just like to clarify the point further. As Mr. Cantor identified, there are a number of heads of claim in these proceedings, not only an expropriation claim, but also heads of claim on other bases. Just to be absolutely clear, the valuations that you have undertaken are only contingent on an issue of expropriation, not on any other head of claim.
Yes, the values attendant to the expropriation for the property taken.
Right. Thank you very much. Second question, just to return to the issue of the date of value, May the 27th, 2008, as you've identified here. You've testified that that date was a date which you were instructed upon But a moment ago, in response to a question again from Mr. Cantor, I think you said, to the extent that you agreed upon this. May I just inquire whether you addressed your mind to the issue of the May 27th, 2008 date and the effect of the Costa Rican Supreme Court decision?
I have.
And did you form the view that that was an appropriate date for an assessment of value?
Yes.
And can you indicate why that was the case? And in particular, I'd like to know whether you took the view, and perhaps that was also whether this was also your instruction, that this was the date on which the expropriation crystallized?
It was my view that this was the date when it became the law of the land. And in looking at the sequence of events, I agreed and concurred with the instructions given to me by counsel that that would be an appropriate date.
You are aware, I imagine, but you can confirm this or otherwise, that the relevant language of the treaty which addresses expropriation and compensation, Article 10, Paragraph 7, talks about the payment of prompt, adequate and effective compensation, and then in respect of compensation says, compensation shall be equivalent to the fair market value of the expropriated investment immediately before the expropriation took place. So are you then expressing a view that the date immediately before the expropriation took place was the date of May 27th, 2008?
Given that that was the date of the decree, it would be May 26th of 2008, which would be immediately before, say the day before. But it would not have changed my value because of the one-day differential. You know, the value would still be the same one day later. So that's how I would answer your question.
Thank you. And then last question, which is to take you back to the language in paragraph 3.1 of your first report, where you talk about market value. And I think this goes to some of the issues on which you had an exchange with counsel for the respondent. You spoke there about acted knowledgeably, and I appreciate that we're talking about a hypothetical willing buyer and a hypothetical willing seller. I'd just like to clarify what you mean by acted knowledgeably. Is this objective knowledge on the basis of due diligence?
Yes.
Would you expect that inquiries would be made more widely about, for example, whether property was inside the park or outside the park, was subject to any blight, whether of law or any other basis?
It goes to the reliance of a purchaser to then inquire of their realtor, broker, attorney, who act in a fiduciary manner to that individual, that any of those issues affecting their value would have been disclosed. So that's how, again, in the context of a market value, one would expect a knowledgeable buyer to have been informed based on their reasonable due diligence in the marketplace.
And for purposes of compiling your report, this is the same kind of due diligence inquiry that you would have made, presumably?
Yes.
I don't imply anything by this question. It's really just a point of clarification. I think in response to questions put to you by counsel for the respondent in respect of the sales contracts, you mentioned that you were informed of them, but you were not provided with those sales contracts because they were, I think the word you used was confidential. Is that correct?
That's correct. The broker, when I inquired, said that he was unable to share them with me because they were confidential.
Do you have any sense of why he regarded those sales contracts to be confidential?
Well, to the extent that he, again, the broker I'm talking about is a Robert Davey, didn't feel that it was in his ability to share them with me because he did not have permission to do so. So in that regard, giving that type of confidential information to a third party like myself is just not usually done. I had asked him, but he said he could not.
Did you form a view as to whether there might have been any information in those sales contracts which you had not seen, which might have been relevant to the due diligence that would need to have been undertaken to form a reasonably knowledgeable view of the circumstances?
based on my inquiry of Mr. Davey during the process, I asked him for the pertinent facts of disclosure of any relevant terms and conditions, and based upon what I assumed to be truthful answers, I did not pursue it any further. And so therefore, my inquiries I thought were appropriate. He gave me reasonable responses. I took them as at their face as being truthful and moved on.
Thank you. Turning to the issue of, again, sticking with the point of knowledge, to the issue of the government's appreciation as to whether properties were within the park or outside of the park, or any intention or inclination to expropriate. Would that have been part, in your assessment, part of the reasonable knowledge assessment that a hypothetical willing buyer would have undertaken?
I'm sorry, I got lost in your question. Could you repeat it? I'm sorry.
Well, the question is simply whether the appreciation of the government as to whether the property remained within the park or was outside of the park, whether there was an intention to expropriate, to the extent that that kind of information would have been available to a hypothetical reasonable purchaser, would you expect that that information would have been sought?
It's reasonable to expect that that information would have been provided by attorneys and or title company and or broker. So you say sought. If it was unknown, you wouldn't know to ask. However, you would have expected through the process that would have been divulged.
In your calculations, in your analysis, were you, or for purposes of your calculations and analysis, were you advised at all on the legal issues and the risks of expropriation?
No, I was not advised, other than from the discussions that I had with the various parties, that there was always some uncertainty as to whether or not it was ever going to take place.
May I just ask you to turn up the letter again from Penelope Lent, which is at tab 3.
Yes.
And I'd just like to take you back, I think, to a sentence in the middle of that letter, which was a sentence to which you were taken to before. However, during this time, I only sold one beachfront lot in the Playa Grande area due to concerns over the legal and expropriation risks upon the creation of the national park. Is that the kind of information that one would have expected would have been in the mind of a hypothetical willing purchaser?
If the purchaser wasn't knowledgeable about the local market, I came in from North America, I would not have known. So to the extent that the broker here in Penelope Lent would have disclosed it then, and in this case, in this lot that she sells, it was her brother who sold the lot to another person. And so, there was full disclosure on her part that this risk could have occurred. So it's not on the purchaser maybe to have known, because they come from different areas in these cases. However, they are relying upon the local broker or the attorneys who have local knowledge then to have shared that with them and apprised them of the risk.
You would expect that as she has disclosed this in correspondence here, and as we spoke about just a moment ago, in talking about knowledge, we're talking about objective knowledge reasonably acquired, that a professional broker, realtor, would have disclosed that information, the expropriation risks upon the creation of the national park.
Yes, so that was, I believe, disclosed through that transaction.
Thank you very much.
Thank you
Very much, Mr. Hedden. I think that brings your examination to an end. So, Mr. Hedden, thank you very much indeed. I'm happy to be able to excuse you from the witness seat.
Thank you.
I think that brings us to the end of our morning session. We can break now. It's now 15 minutes to the hour. We'll break now until 2:15. Yes, Mr. Alexandrov.
Mr. President, may I make a very brief point in in response to Mr. Cantor's admonition about the questions being asked by the tribunal in relation to damages, I just want to state for the record, on behalf of respondent, that this is a unitary proceeding which captures jurisdiction, liability, and damages. This hearing may be the last opportunity for the tribunal to interact with witnesses, experts, and for that matter, counsel. And we appreciate that the tribunal will want to have a complete record in front of the members of the tribunal before deciding on any of those issues. And therefore, we appreciate that the tribunal will ask any questions that the tribunal wishes to know about in any of the areas of jurisdiction, liability, and damages. And on behalf of respondent, we do not draw any conclusions as a result of that.
Thank you very much, Mr. Alexandrov. I take that no need for Mr. Copa to echo your words. As I said at the outset, don't assume that we know where we're going. We're not sure where we're going at the moment. But as you say, this is an opportunity in a composite proceeding for members of the tribunal to ask the questions of witnesses who are currently in front of them. So thank you very much. We'll adjourn now until 2:15. Thank you.